Asylum and Mandamus lawsuit. Remember, this year we are not going to be taking unreasonable delays as a simple response. We are going to respond accordingly. Therefore, we are going to be filing lawsuits in federal court when it comes to really setting the record straight for unreasonable delays. In this video, I'll talk about lawsuits, mandamus lawsuits in federal court. Really, when it comes to unreasonable delays, we are going to talk to you about some strategies so that USCIS doesn't fight back, because you want to go there and just win. And the goal is for basically the court to order USCIS to adjudicate your petition, but you have to prepare so that the court is convinced with your argument. Okay, so that's what we do. That's why we're here, right? So to help you accelerate this immigration process so that you can get a solution and eventually bring your family, reunite with your family. We'll talk about it, and we'll talk about this lawsuit pending with I-601A waivers applications. It's a class action lawsuit that is currently pending. Okay, let's get right into it. My name is Bijou Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, don't forget to comment below. Also follow me on all platforms because we are going to be growing our community. And remember, this month of February, we're going to do some live shows, okay, where you ask your question live. I'll let you know for sure, but we're going to test it at least this weekend to see how it plays out for us. If we don't test it this weekend, we'll test it early next week and see how it's going to go for us, because we really want to give you the opportunity to ask us questions, and we want to get to know you too, right? It's a give and take, right? You give, you take. That's how it works in this world. Let's get again right to the subject. Mandamus lawsuit and asylum cases. Okay, how can you go about it? Basically, if you have an asylum case pending, right, for a long time, because we have people with asylum cases that have been pending for at least since 2014. Okay, they haven't been called for interview. However, they do have some type of work permit. They can renew the work permit, but again, they have families, right, left back home, and they wonder, when am I going to be able to bring my family? So this is how you go about it. You have to do an assessment of your case to give it a chance, some weight. First of all, 5 years and up is unreasonable. We can just say it's unreasonable. If it's 4 years, it's debatable based on the backlog. USCIS might fight back. But when we start with 5 years and up, like right now we're working with a client where his case has been pending with USCIS for 7 years. This is actually unreasonable, okay? But anyway, so we start with 5 years, okay, and up. Case pending with USCIS, so unreasonable. Then the second question is, well, what have you tried? Have you tried expedited requests based on humanitarian reasons? We know that you can expedite your request provided the USCIS agrees to expedite your request. Under humanitarian reasons, you can expedite it for, let's say, death of a family member, serious illness of a family member. To give it a chance, it has to be like immediate family member. We're talking about spouse, parent, or child, right? You can expedite your case based on disability of a family member or your own serious illness, maybe your own, right? So you can expedite your case, really, and those are humanitarian reasons, welfare reasons. You can expedite your case. Have you tried that? If it didn't work out, if you try reaching out to ombudsman office, if you try reaching out to your member of Congress, if you try something, right? Because you want to show the judge that, look, this has been going on for too long. I've tried this, I've tried that. USCIS is not responding. We think that USCIS really is being unreasonable at this point, right? Then that's we talked about timing, right? How long it has been. I'm going with 5 years and more, okay? Then we talk about actions. What type of actions have you, did you take any type? Expedite request, ombudsman office, calling Congress, something. Did you do any of those? Then we go to the third question. Is your case strong enough in case you get the judge to order USCIS to respond? Basically, USCIS is going to call you for the interview, but is your case strong enough? Are you prepared to go through, in case you get denied, are you prepared to go to removal proceedings, mentally prepared with evidence? Are you prepared? So the way you might assess that is by asking yourself if you have U.S. citizen children, or you have some type of extreme hardships, or you have your family member back home, somebody's really going through something, right? Like they're receiving threats, serious illness and stuff like that. Those are convincing points, right? Then once you assess your case like that, then you come to us. We go again through the assessment, we gather evidence, then we file a lawsuit in federal court so that we can get the judge to decide whether the 7 years or 5 years or 6 years or 10 years period of time that you've been waiting, whether it's unreasonable. And most of the time the judge will agree that it is unreasonable and then order USCIS to adjudicate your case. So at that point, when you go to USCIS, are you prepared to defend your asylum case? And if things doesn't go your way, are you prepared to stand up in court, right? Are you prepared to fight in court as well? Do you have any additional evidence? Do you have something that can help you out? For example, if your case has been pending for 10 years, right? And then let's say you have U.S. citizen children, and then now you go, the judge orders USCIS to tell them to decide on your case, and you go to the interview and it doesn't work out for you, and you've been here for 10 years. Well, when you go back to court now, immigration court, not going back, but when you get referred to immigration court, what type of defense do you have beside your asylum? Do you have cancellation of removal as a defense? Do you have stay of removal as a defense? So those are the things we help you assess before we file the lawsuit, okay? So that you can be comfortable, and we can be comfortable in case things doesn't work out for you at the USCIS level. Not just that, we want to assess your case because we don't want to go to federal court and allow USCIS to find some weakness in the case and fight back. So you don't want to waste your money like that. That's why we do a preliminary assessment of the case. You can schedule your consultation by using the link in the description box below. And let us help you reunite with your family, because that's our goal. We said it, we're going to say it again. We are not going to take anything as unreasonable. We're going to try expedited requests. I've tried with some couple of my clients with their VAWA petitions, and USCIS has responded accordingly. So we'll try things. If those things don't work, we go to court, because that's the system, the way it works. You go to court and the judge decides, okay? So then we have a great news for I-601 applicants, waivers of unlawful presence. There is a class action lawsuit going on, and the class action is good because the moment they get a certification and they get a response from the court, it's going to include everybody that fits the agreement, okay? So they're talking about if you have an I-601 that has been pending for 12 months or more, you'll be part of the class action in terms of the result of it, the benefit of it once they win. Okay, so the reason they are filing a class lawsuit, those litigation teams, some immigration lawyers and some other organization combined, filing that lawsuit, it's because some I-601A waivers have been pending for 31 months, pretty much 3 years. It's like, that's insane. So they had no option but to go to federal court to ask the judge to order USCIS to adjudicate those petitions as soon as possible. So we are waiting for the response. Anytime soon we will know. I'll communicate with you. But that's a great news because it's going to include some people that has the I-601A pending for at least it's starting with 12 months, right? Provided that I guess one of the criteria is that you are here in the U.S. So, and basically that's how I-601 works. Anyway, you are here in the U.S. and you want to go back. So, but some people apply for it from outside, but that's not the way it works. It works best when you're here in the U.S., unlawful presence into without inspection. That's why you want to basically apply for I-601 so that you can be able to go back and get your visa from outside because you enter without inspection. Okay, and not just that, or maybe you marry a lawful permanent resident, so you cannot waive unlawful presence here, so you just have to go outside of the U.S. So again, this is something to really follow. For people who have I-601A pending, applications pending, or somebody, family member, anybody, right? Friends, family member, we're here to spread the word, right? Family members, enemies, you just give it to them, okay? So that's it. Again, if you need a consultation and you feel compelled to file a lawsuit with against USCIS for your unreasonable delay, or you want to file a lawsuit based on the how they call it, 221G refusal, or basically case pending at the consulate for too long, schedule consultation by using the link in the description box below. Until next time, bye bye.